Usually when I'm scrolling through sources for our deep dives, I sort of gloss over anything that looks like standard bureaucratic paperwork.
Hmm.
You see a title like General Memorandum of Law Public Advisory, and your brain just automatically goes into, screensaver mode.
It really does. It has all the visual cues of a boring administrative filing.
Yeah.
It's dense. It cites a lot of case law. And, it doesn't have a catchy cover.
But then I started reading this specific one, this document out of Hawaii, and about 2 paragraphs in, I actually sat up because I realized this isn't just a memo. It reads more like a warning shot,
Oh, yeah.
or maybe a chess move disguised as paperwork.
That's a great way to frame it. It looks like a standard memo, but functionally, it's a high-stakes strategic play about who actually holds power, the government or the people.
Exactly, and it's weirdly aggressive for a memo. It says right at the top it concerns constitutional, natural law, and due process principles, but then it has this disclaimer. It says it is advisory in nature and does not command action, request relief, or require response. So I have to ask the obvious question here. If they aren't asking for anything and they aren't suing anyone yet, what is the actual mission of this document? Why are we doing a deep dive on it?
We're diving into it because it illustrates this fascinating legal mechanic. It's called a public notice instrument. To get the mission, you have to look at what happens after this document is filed. This isn't a protest sign at a rally that gets thrown away.
No.
It's a formal entry into the public record. Its goal is to strip away the government's ability to say, oops, we didn't know.
The plausible deniability factor.
Precisely. It's laying a trap. It's essentially saying to legislators, here are the rules of the road. We have formally handed them to you. If you crash the car now, you can't say you didn't see the speed limit signs.
And as we're going to see, that distinction knowing versus not knowing, that changes everything when it comes to who gets in trouble. Not just the government as an entity, but the actual humans signing the bills.
That is the crux of it. So for this deep dive, we're going to treat this as an objective legal analysis. We aren't here to take a side on the politics or the specific grievances, but we need to unpack the legal argument this document constructs. Because if this logic holds, it really flips the traditional power dynamic on its head.
So let's start at the bedrock then. Before we get to any threats of lawsuits, the document spends a lot of time on philosophy. It tries to establish where rights actually come from. I think if you ask the average person, who gives you your rights, they'd probably say the Constitution or the law.
Right. And this memorandum says absolutely not.
It's pretty blunt about it.
Yeah.
Section 3, governing legal principles. It uses the phrase unalienable, God-given, natural, medical, and human rights.
It's a mouthful, yeah. But the order of those words matters. They're asserting that rights are pre-political. They exist before the government is even formed. The document makes a really critical distinction. Rights are recognized and protected by law, but they are not created by law.
Okay, let me play devil's advocate for a second. Why does that distinction matter, practically speaking? Whether the law gave me the right or just recognized it, I still have the right, don't I? Does the source really change the legal reality?
It matters immensely. It's all about ownership. Think of it this way. If the legislature grants you a right, like they grant you a driver's license, then the legislature owns that right.
Okay.
They can modify it, they can suspend it, or revoke it whenever they feel it's necessary for the public good. It's basically a privilege they are lending you.
Like my gym membership. They gave it to me, they can take it away if I break the rules.
Exactly. But if you accept the premise of this memorandum, that these rights are inherent, natural, or God-given, then the legislature has zero ownership over them. You own them. The legislature's only job is to protect them. And that leads to this concept of delegated authority, which is just central to this whole text.
I saw that term a few times, limits on delegated authority. So in this worldview, the government isn't the boss.
No. In this framework, the government is the tenant, and the people are the landlord. The tenant only has the rights the landlord wrote into the lease.
The lease being the Constitution.
The Constitution, exactly. They can't just decide to knock down a wall or sublet a room unless the lease says they can. This memorandum is basically the landlord stopping by and saying, hey, just a reminder, you don't have permission to paint the walls.
And it sort of implies the tenant has been painting the walls for a while without checking.
It does imply that. And this is where the document gets interesting about its own validity. It references that it isn't a standalone complaint. It mentions these accompanying documents, the Clean Instrument Hawaiʻi and the Hawaii People's Scroll.
Yeah, those sounded very, National Treasure-esque. I didn't see the text of those, but what are they referencing there?
So in legal terms, they're establishing a chain of title or their standing. A clean instrument usually refers to a document that establishes clear, unencumbered standing or ownership. They're building a paper trail of sovereignty. It's their way of saying, we aren't just random complainers. We have the documentation to prove we are the landlords. They're establishing a whole legal and lawful framework to show they have the authority to issue this notice in the first place.
There's another phrase in the background section that jumped out at me. It felt very relevant for anyone who's ever just, gone along with a rule they hated. It says, silence, participation, or compliance must not be construed as consent.
Ah, yes, that is a defensive maneuver. In contract law and often in governance, there's a doctrine called acquiescence. If I start building a fence on your property and you watch me do it every day for a month and say nothing, a court might later say you consented to the fence.
You lost your right to complain because you were silent.
You were silent, so you accidentally agreed.
So this is a preemptive strike against that.
It is. It's stating on the record. Just because we are following your rules to avoid being arrested, or just because we are using your services, does not mean we agree you have the authority to do this. It preserves their standing to sue later on.
It's like signing a document under duress.
Exactly. And that sets the stage for the second part of the argument, which is where things get really sharp. We've established the philosophy rights come from the people. Now, how does this document turn that philosophy into a weapon?
This is the part I call the trap, because the document is titled Public Advisory, and that sounds so helpful, right? Here's some advice, neighbor.
Right.
But you're saying it's actually all about liability.
It is about liability, but specifically through the mechanism of notice. In the legal world, notice is like a magic switch.
Yeah.
It changes the nature of an offense completely.
Okay, give me an analogy. How does telling someone, I think you're wrong, change the whole legal outcome?
All right, imagine a bridge is out on a dark road. If a driver goes down that road and crashes, it's a tragedy, maybe an accident. The town might be liable for negligence, but it's passive. However, if a town puts up a giant flashing neon sign that says, "Bridge out, do not enter," and the driver sees it, ignores it, and crashes, that's no longer an accident. That's recklessness. Or in legal terms, willful misconduct.
So this memorandum is the neon sign.
Correct. It places lawmakers on clear notice. It says, "We have told you, with citations, that this proposed legislation violates fundamental rights." Once that notice is on the record, a legislator can no longer say, "Well, I didn't know it was unconstitutional. I'm not a lawyer. I was just following procedure."
They can't play dumb anymore.
They cannot. And this leads to the most dangerous part of the document for a politician, the section on individual capacity liability.
This was the wait, what moment for me.
Yeah.
Usually when the government screws up, the government pays, the agency pays, which really means,
Taxpayers pay.
right, we pay for their mistake. But this document is threatening the actual person, the official.
Yes. And this is where we have to talk about qualified immunity. This is the legal shield that usually protects government workers. You know, police officers, school principals, mayors. They generally cannot be sued personally for just doing their jobs, even if they make a mistake.
It's a pretty strong shield, right? You almost never hear of a mayor losing their house because of a bad law.
It is very strong.
Hmm.
But, and this is a huge but, that shield has a piercing point. The Supreme Court has ruled that you lose that immunity if you violate a statutory or constitutional right that was clearly established at the time of your action.
Clearly established. That's the key phrase.
It is. So usually an official argues, the law was fuzzy, I didn't know for sure it was a violation. But this memorandum, it acts as a dossier of evidence. It's designed to make the law clearly established on the record. It's arguing, we explained the law to you, we cited the Supreme Court cases, you read it, and then you voted for the bad law anyway.
So that moves it from an oops to knowing and willful.
Exactly. And if a court agrees that the violation was knowing and willful, the shield of qualified immunity just evaporates. The official can be sued for damages out of their own pocket, their house, their car, their savings.
That creates a massive chilling effect. I mean, if I'm a local representative and I get this document on my desk, am I going to risk my personal 401k just to vote yes on some party line bill?
That is exactly the calculation they want the official to make. It raises the personal cost of just rubber stamping policy.
But does this actually work? Or is it just a paper tiger? I mean, have we seen this notice strategy actually stop legislation?
Well, it's difficult to prove a negative.
Yeah.
We don't always know when a bill wasn't introduced because a lawyer got scared. But legally, the mechanism is sound. Courts routinely look at legislative intent. If the record shows they were warned and ignored it, it implies a level of arrogance or, disregard for the Constitution that judges do not like.
So what kind of policy are they trying to stop specifically? The memorandum isn't just a blanket, don't tread on me. It gets very specific in Section 3. It talks about bodily autonomy and due process.
Yes, the triggers here are clearly related to medical mandates, parental authority, and physical privacy. It creates a sort of checklist for what constitutes a violation.
I found that checklist really helpful because due process is one of those terms we hear all the time, but I'm not sure I could define it at a dinner party without stumbling. The breakdown here is very specific. It says a law raises due process concerns if it conditions access to services on a waiver of rights.
That is a classic constitutional battleground. It's the unconstitutional conditions doctrine. The government can't say, sure, you have a right to free speech, but if you want to get a building permit, you have to promise never to criticize the mayor.
Or, in this context, you have a right to bodily integrity, but if you want your kid to go to school, you have to waive that right.
Precisely. The memorandum argues that this is coercion, not consent. And it points out that when the government wants to burden a fundamental right, like what you do with your own body courts, are supposed to apply strict scrutiny.
Strict scrutiny. That sounds like a terrifying teacher looking over your shoulder during an exam.
In court, it's worse. It's the highest standard of judicial review. It's a red alert. If a law triggers strict scrutiny, the government has to prove 3 things, and they are very hard to prove. 1, they have a compelling interest. like stopping a deadly plague. 2, the law is narrowly tailored.
Meaning it doesn't affect anyone it doesn't have to.
Right. And 3, it's the least restrictive means to solve the problem.
So they can't use a sledgehammer if a scalpel would work.
Exactly. And most broad mandates fail this test because they are sledgehammers. They hit everyone, regardless of individual risk. This memorandum is reminding them, if you pass this, you are walking to a strict scrutiny buzzsaw and you will likely lose.
Which brings us to Section 4, legal and practical risks. We talked about the politician getting sued personally, but what about the system itself? If they ignore this advisory, what happens on the ground?
Chaos, essentially. The document warns of challenges to enforcement actions. Just think about what that looks like. The legislature passes a law, but now every time a school principal tries to enforce it, a parent hands them a copy of this legal notice.
Oh, wow.
Every time a medical board tries to pull a license, the doctor sues using this framework.
It just clogs the gears of the bureaucracy.
Completely. And creates what the document calls long-term invalidation risk. This is the sunk cost argument.
Explain that.
Okay, imagine the state spends $10 million setting up a new compliance database, hiring inspectors, printing forms, training staff. 2 years later, a judge looks at the record, sees this public advisory, sees the legislature was warned the law was unconstitutional, and strikes the whole thing down. Poof.
$10 million down the drain.
And the public trust with it. The argument here is economic as much as it is legal. They are telling the government it is cheaper to follow the Constitution now than to pay for the lawsuit later.
That's a compelling pitch. Money talks. But I noticed the document isn't purely combative. It doesn't just say, don't do this or else. Section 5 is called recommendations. It actually offers a path forward.
That is what elevates this from a rant to a professional legal instrument. It offers an off-ramp. It acknowledges the government has legitimate goals, but suggests ways to achieve them lawfully.
What does an off-ramp look like in this context?
Simple things that legislatures often skip. Narrowing scope. Don't write a law that applies to everyone if you only need to target a specific high-risk group. Or providing opt-out provisions.
Right, like religious or medical exemptions.
Exactly. Often, simply adding a robust exemption clause is enough to save a law from being struck down. It shows the court that the legislature was trying to balance state interests with individual rights. The memorandum essentially says, if you really need to pass this, at least add these safety valves so you don't violate the Constitution.
It also suggests delaying enactment for further study.
Which is legislative code for, let's all take a deep breath and actually read the bill.
It's an interesting strategy. It's adversarial in its defensive rights, but it's cooperative in its presentation of solutions. It's like, help us help you not get sued.
That duality is key. If you just scream tyranny at a legislator, they tune you out. But if you present a memorandum of law that cites Supreme Court cases and offers drafting amendments, they have to hand it to their general counsel.
And their general counsel.
Their general counsel is going to look at that individual liability section and say, boss, we need to tread very carefully here.
So stepping back for a second, we've got this dense document from Hawaii. It talks about natural law, qualified immunity, strict scrutiny. It's heavy stuff. But why does this matter to the listener who isn't a lawyer and doesn't live in Hawaii?
It matters because it demonstrates a method for civic engagement that is far more potent than just voting every 4 years. Most people feel helpless against the government machinery. They think they're going to pass what they're going to pass.
Right. We feel like spectators watching a game we can't influence.
And this document shows that you can stop being a spectator. By creating a record, by formally asserting the law, we, the people, can actually shift the burden of proof. It reminds us that the law isn't some secret code owned by the government. It's publicly accessible, and it can be used by the public against overreach.
It goes back to that landlord-tenant analogy you made earlier. You can't just complain to your spouse that the tenant is painting the walls. You have to send a formal notice.
The record matters. In the legal world, if it isn't written down, it didn't happen. What this group is doing is writing it down. They are creating the history they want the court to read later.
I want to leave the listener with one thought that really stuck with me. We talked about silence is not consent. In our daily lives, we let a lot of things slide. We click accept on terms of service we don't read. We follow rules that make no sense just to avoid a hassle.
We trade rights for convenience constantly.
We do. But this memorandum suggests that every time we do that, we are eroding our own standing. If fundamental rights pre-exist the government, then a public advisory like this isn't asking for permission to be free. It's a notification of terms. It makes you wonder, how many other leases are we letting the government violate simply because we haven't bothered to send them a notice?
That is the ultimate question of sovereignty, isn't it? If you don't enforce the contract, you don't really have one.
A huge thank you to everyone for tuning in to this deep dive. Just a quick disclaimer, as stated in the source material itself. This discussion is for civic education and reference only. We aren't lawyers giving you advice, and we certainly aren't telling you to stop paying your parking tickets.
Always read the fine print.
Always. We're just two people fascinated by the machinery of rights. Until next time, keep reading the rules.